Let us start with the first one, habeas corpus, and I am pretty sure that most of you have a decent background of understanding what is habeas corpus. Habeas corpus is a judicial review issued by the Supreme Court or a High Court in India, directing any public or a private agency to release a person in their custody. So, the basic purpose of the habeas corpus is to protect the personal liberty. So, whenever a person's detention is illegal and the detention is either by the public authority or even by private authority, you could ask for writ of habeas corpus. The word habeas corpus is a Latin term which means you must have the body. That means you could understand, in case if a person is illegally detained, the writ could be issued to release this person from the illegal detention. And initially this writ was developed for the purpose of producing the person from illegal detention before the court. However, now it is much more than what it is. Even in the course of time, we will see how this writ of habeas corpus was issued by the courts to stop even torture during the detention. So, because of later developments in habeas corpus petition, now production of a person before the court is no longer an essential ingredient. While issuing this writ of habeas corpus, the court will go into the justification behind such detention, and the writ is applicable to all kinds of wrongful deprivation of liberty. So, what we could look at now is that who could file this writ of habeas corpus? We knew that writ of habeas corpus could be claimed when the detention is illegal. Who can claim? Of course, as we already discussed the traditional rule, the first one is the detainee himself. But do you seriously think that the detainee could file a habeas corpus writ petition when he is illegally detained? If he has an access to the outside world, which is generally not in case of illegal detention, so therefore it is humanly impossible for most of the illegally detained persons to ask for writ of habeas corpus on their own. Therefore, the Constitution allows that the writ of habeas corpus could be claimed by any person on behalf of the detainee. That means even a friend or any family member could go to the court for release of a person who is illegally detained. So, on behalf of the detainee, anyone can go to the court. And in case of a minor, a guardian or a person who is entitled for the custody of the minor could also file a writ. Now, with the invention of public interest litigation, any public spirited person can prefer the writ in the interest of the person who is illegally detained. And there were a number of instances where the detentions were illegal in a sense that many of the under trial prisoners were detained for months and years together when they without any trial. Several public interest litigations were filed before the Supreme Court to release these under trial prisoners. So, therefore, a habeas corpus petition could be filed by any public spirited person. Then comes the question is, when we talk about detention, means a person must be in the custody, and if the custody is illegal, you claim habeas corpus. But what is the meaning of custody? Custody in general terms means detaining a person physically. However, for the purpose of writ of habeas corpus, a physical confinement or locking a person in a room is not necessary. What is expected or what is the meaning of the custody for the purpose of habeas corpus petition is that some kind of a control over the movement of a person is necessary. That is sufficient to approach the court. For example, if a child is prevented from going out of the school or leaving the school, it is a custody, child is under the custody. So, or if a child is prevented from meeting a parent, or if a parent confines a child not allowing to meet the another spouse, or if a child was kept at home not allowed to go out on the ground of lunacy, still we could say that he is under the custody. or if a employer does not allow the employee to go out, we could ask for a writ of habeas corpus. So, therefore, the custody does not mean physical confinement, some kind of a control over the movement is sufficient to claim. So, does it amount, for example, if a person was arrested and he was convicted and he was lodged in the jail, can we ask for writ of habeas corpus? This question has came in Sunil Batra versus Delhi administration, a little different facts. What happened in this case is one of the convict in the jail was tortured by the police, the jail authority, I am sorry. So, the question before the Supreme Court is that if a person was legally detained under a competent court convicted the person undergoing the jail term, if there is a inhuman treatment in the prison, could we claim habeas corpus petition? So, in this case a letter was written by a petitioner to the court alleging that there is a torture against the convicts. The Supreme Court said that even though habeas corpus is generally issued for release of illegal detention, but in this case the detention, though legally permissible, becomes illegal due to unlawfully imposing the torture against convicts. Hence, a writ of habeas corpus could be issued to stop the torture. So, therefore, if a detention is still legally possible and legally valid, but if the authorities did not follow the procedure, caused any inhuman treatment for them, a writ of habeas corpus could be issued, not to release them, but to stop the inhuman treatment. Now, on what grounds we could ask this writ of habeas corpus? So, there are several grounds, a few of them we could just discuss. One is if the detention contravenes a fundamental right. That means, if a person was detained which amounts to violation of a fundamental right, you could ask for writ of habeas corpus. Similarly, when a detention made against the law, they violate any principles of law, or a detaining authority was not properly constituted under the law. That means, a person, a authority who is detaining you was not authorized by the law, or detention order is in contravention with law, or a person who detains you is without any authority. That means, suppose you do not have an authority to detain a person, but still you detain, that is a ground for habeas corpus. The detention beyond the prescribed period, that suppose a person could be detained not more than a month, but if the person detained more than a month, for example, under article 22, once a person is arrested by the police, he should be produced within 24 hours before the nearest magistrate. If he is not produced before the nearest magistrate within 24 hours, his detention becomes illegal and you could ask for a writ of habeas corpus. Or even failure to comply the procedure. For example, if there is a procedure for arrest, if you do not follow that procedure strictly, it also amounts to illegal detention. Then you can ask for writ of habeas corpus. And further, the failure to comply with the requirements by law in the during the detention, that means you are legally detained, but within the detention you are not following the principles of law, still you could ask for writ of habeas corpus. Now, during the proceedings, the court can also look into the validity of the detention. That means, is not only release you, but also it looks at whether the detention is legally permissible, whether it is an illegal detention. And further, the Supreme Court has expanded the scope of habeas corpus petition to deal with illegal detentions. For example, if you are detained illegally, in addition to the release, could you ask for a compensation from the state for illegally detaining you? The Supreme Court, accepting this contention in D.K. Basu versus State of West Bengal, said that even you can pay, you can order compensation in case of illegal detentions. Similarly, in Neelavati Beharas versus State of Orissa, the compensation to the victims of torture in the police custody is permitted by the Supreme Court. That means, it is not only mere release, but also a compensation could be offered in the writ proceedings. So, now fairly we have some idea about when you can claim writ and how you can claim and where, who could claim. Let us look into when you cannot claim writ of habeas corpus. Number 1, to question the propriety of lower court's decision of conviction. That means, if the lower court convicted an accused, and if the whether the conviction given by the court is proper or not, you cannot go to Supreme Court or High Court under writ of habeas corpus to test it. It is not allowed. Or similarly, if a lower court refused to give a bail, or if the lower court did not follow the procedure while deciding the case. So, in all these cases, you have no right to ask for writ of habeas corpus. Why? The only remedy in those cases is go by a appeal. That means, you cannot ask a writ of habeas corpus on any order issued by the court regarding detention. If you feel that it is illegal, make an appeal to the Supreme Court. And the another circumstance where you cannot ask for writ of habeas corpus is when a person is released on bail even though the detention is illegal. So, the basic purpose of the habeas corpus is to release the person from the detention, but if he is already released on bail even though his detention was illegal, you can't ask for writ of habeas corpus. Similarly, you cannot file a writ of habeas corpus to punish the authority who illegally detained. That means, the purpose is only to get the release of the detainee, but not to punish the detaining authority. So, for that a separate case has to be filed and it cannot come under writ of habeas corpus. Now, let us look into what is the procedure. How do we file the writ of habeas corpus? Because as we know that it is for the protection of your life and liberty, there is no strict procedural rules were made for approaching the Supreme Court or High Court. And in fact, in Sunil Batra versus Delhi administration, as we discussed earlier, even a letter addressed to a judge was accepted as a writ petition. And in many times, the court issued writs on suo motu by reading into the newspaper reports. In number of cases where the newspaper reports that there is a lot of illegal detentions in the jails, the Supreme Court issued a suo motu orders. So, therefore, there is no strict procedure. However, when you are filing a petition under the to claim writ of habeas corpus, you need to attach the petition an affidavit stating that the circumstances under which a person was detained and how it is a illegal detention. If the Supreme Court or the High Court satisfies that there is a prima facie cause, the court would ensure the presence of the detaining authority, verify whether it is illegal detention, then accordingly issue the writ. However, a delay in applying the writ has no bearing on issuing the writ. That means, if a person was illegally detained, say for example from last 6 months, and now we approach to the court to issue this writ, the court would not ask you why you did not approach in the beginning, because as long as this detention is continuing, is a continuing wrong, hence the writ would be issued. And the most important aspect of this writ is the general principle of res judicata. That means, approaching the court more than one time on the same facts and same circumstances and the same court does not apply for writ of habeas corpus. That means, writ of habeas corpus successive petitions are allowed. If it is rejected by the court on the same grounds, you can again go to the court. And for the same purpose, even the constructive res judicata would not apply. That means, usually in a petition you have to ask all or raise all the grounds that you want to raise. Suppose you did not raise a issue, the constructive res judicata says that the issue is raised and the court rejected, but that does not apply in case of habeas corpus. And also the court do not insist the standard of proof, usually it insists like beyond reasonable doubt. If there is a prima facie case, that is sufficient, and the burden on the petitioner is much less compared to other proceedings. And the most important thing is, if you could satisfy the court that there is a prima facie the detention is illegal, that is it. You could fairly expect that the court would be issuing a writ of habeas corpus. So, therefore, on whole, the habeas corpus petition could be issued for the purpose of release of a person, and it is one of the very, very important aspects.